Hello and welcome to Family Law Now After Hours. And before we dive into today's topic, just a few quick housekeeping items that I want to make note of. We are here to provide valuable insights on separation, divorce, and family law in and of itself. Just please remember that any information shared in this series should not be taken as legal advice. Today's topic is spousal support, eligibility, and obligations, where we'll be covering a variety of aspects that shed light on various spousal support matters. So if you have any personal inquiries about your specific situation, we highly recommend reaching out to our office or consulting with a lawyer in your area to get personal tailored advice. And now to the introductions. We have Shanza, who is a recent law graduate from Osgoode Hall Law School, and she is an articling student at the firm with plans to be called to the Bar of Ontario in June 2024. She's focused on launching her legal career in family law and is dedicated to providing empathetic and proficient legal support for those navigating family-related complexities. Her valuable experience stems from active participation in legal clinics, mooting competitions, and prior work as a legal assistant. As she embarks on her legal journey, Shanza is poised to contribute to the firm's commitment to excellence in family law, leveraging her diverse background and unwavering dedication. Russell Alexander is the founder and senior partner at Russell Alexander Collaborative Family Lawyers, and with over 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them cope with the difficulties of separation and divorce. Russell has written 4 books and is a fully trained collaborative practice lawyer, and he speaks at conferences on collaborative practice, marketing, technology, and the law all over North America. Steph has been with the firm since 2018 and was called to the Bar of Ontario in 2022 and is now an associate lawyer at the firm. Steph completed her undergrad degree at Queen's University and obtained her law degree from the University of Liverpool in 2020 and graduated with first-class honors. Like all the other lawyers you see on your screen, all 4 of us are trained as collaborative practice lawyers, and Steph is committed to assisting clients through what is traditionally a difficult time by approaching matters with empathy, integrity, and compassion. Now, last but certainly not least, myself, who is also an articling student at the firm, and I'm set to be called to the Bar of Ontario in June 2024. As a graduate of the Ted Rogers School of Management at Toronto Metropolitan, formerly Ryerson University, as well as Queen's University Faculty of Law, I enter the next phase of my legal career, and I'm committed to positively influencing the lives of those facing difficult family situations. Outside of the office, I love playing hockey, unwinding with comedy movies, and cheering on the still not struggling Maple Leafs. Although they had a brutal game yesterday, but we're gonna out of the heads, scratch that. We're not gonna talk about last night. We're gonna move on to tomorrow against Buffalo.
Are they going to make playoffs?
Yes.
When are playoffs? Are they coming up soon?
April.
Yeah. Okay.
We'll be good. Bad game yesterday, but we have Buffalo tomorrow. We'll be okay.
Who's number 1? Is Detroit still number 1 in that division?
No, Florida's really up there. Boston's up there, but Florida's going to be they might be a President's Trophy winner this year.
Who would have thought, right?
Florida's playing great. Vancouver, a lot of great teams. Anyways, sorry. back to spousal support. So we have a lot of great topics today. We are going to begin first with the purpose of spousal support as well as eligibility criteria. So, what is spousal support? So spousal support, which is sometimes referred to as alimony or maintenance, those words get tossed around very frequently, but predominantly we use the term spousal support. And it is financial assistance that's paid from one spouse to the other after separation or divorce. And the most common question we get is, why does it exist? So spousal support serves several crucial purposes, 4 big ones, really, to be specific. First, it aims to help a spouse become financially independent once again after the separation or divorce. And the law has a heavy focus on self-sufficiency, and that issue comes up in almost every spousal support case we see. Secondly, it acts as a safety net, and it prevents a spouse from facing severe financial hardships due to the breakdown of the relationship. And this is especially the case if there was only one spouse in the working force while the other stayed home with the children or is maybe going to school. Thirdly, it basically continues to help share the financial responsibility of caring for any children involved in the relationship, ensuring that their well-being is maintained. And this would also be in addition to the child support already being paid. And finally, it also compensates one spouse for any financial disadvantages they may have faced during the marriage or common law relationship, such as leaving their job to care for the children or even sacrificing job promotions. And on that note, really, when spousal support is ordered by the court, it's typically paid by the spouse with the higher income to the one with the lower income, and that allows the parties to roughly have similar net disposable income. So net disposable income is the residual after paying your taxes. So it's like the final amount of money that you have to be able to spend. And with respects to eligibility criteria, there are a few key things to consider. Firstly, one might be entitled to spousal support if you were married. So that's one sort of box that you can check off. But even if you weren't married, you could still qualify if you live together, if the parties live together as a couple for at least 3 years, which is known as common law, and that's a common law relationship, or if the parties were in a relationship of some permanence for any length and you had a child together, you might as well still be, you may still be eligible as well in that sense. Now, in order to prove that you're eligible, you'll need to demonstrate a few things. So firstly, you could show that during the relationship, you had responsibilities that made it tough for you to build your own career. So that can be things like taking care of your children or supporting your partner's career. And alternatively, if after the separation, you're struggling financially and your ex has enough resources, whether that be through income or assets to provide support, that counts as well. And also, finally, if you've got a legal agreement, and that can be either a separation agreement or a form of a prenuptial agreement stating that you'll receive spousal support upon separation, that's also a valid eligibility requirement that you can use to demonstrate. And with that, the court also takes other factors into account, like the parties or the recipient's age, their health, childcare needs, the payor's ability to pay. So the payor is the person who is not the recipient, but the one actually making the payments, as well as if the payor is already paying the recipient child support, if there is a dependent child to the relationship. And the court's ultimate goal is basically to ensure that everything's fair and reasonable in determining whether you're eligible for spousal support or not. I know it was a handful, but there's a lot that goes into eligibility and pretty much the purpose of spousal support altogether.
Yeah, it's really an interesting discussion. A lot of people and a lot of lawyers don't even think about the very first step, Joseph, entitlement. So you might be eligible for spousal support, or there may be a rational purpose for you to get support. You don't have any money. But the first hurdle people need to get over is this idea of entitlement, which often gets overlooked, right? Like Stephanie says, we can do an hour on each one of these subsections, but just keep that in the back of your mind when making a support claim or defending a spousal support claim. This concept of entitlement and whether the other spouse even has entitlement to support.
Yeah, and that actually sort of ties nicely into the two types of support. Sorry, John, I'm just sort of jumping right in,
Do it.
taking the reins. But like Russ said, the crucial first step before any application of what's called the spousal support advisory guidelines. Last week we talked about the child support guidelines. This week, the Bible, the master, plan it stems from the spousal support advisory guidelines, or SAGs. It's a mouthful, so we'll just shorten it to SAGs. But yeah, that first step, is an analysis of entitlement. And when we talk about support, you'll hear terms thrown around like compensatory, non-compensatory, and what those mean is the two types or the two bases for entitlement. So compensatory claims, those are those based either on the recipient's economic loss or disadvantage due to the roles adopted during the marriage or the relationship, or the recipient's gift of economic benefit to the payor. So common, markets of compensatory claims are, one parent stayed home with the kids, looked after the house. One parent was historically a secondary earner or receiving more passive income and taking a different type of, a homebody role. Maybe one spouse continuously moved for the payor's career to support and aid in their career growth. Maybe one spouse supported the other's education or training, or someone had primary care of the children after separation. So that's sort of one stream, one avenue is that compensatory to compensate for sort of the sacrifices you made during the course of the relationship. It's to be distinguished from non-compensatory support, which were their claims based upon need. So usually to sort of differentiate, we might call that needs-based support. And this sort of like Joseph was saying is it's, what happens if when parties separate, the other just financially cannot be self-sufficient from the get-go. So maybe they have an inability to meet basic needs, or maybe it's, interpreted to cover a significant decline in the standard of living from the marital standard. So if you've spent your life, eating filet mignon and, going out to eat all the time, and then all of a sudden you don't really have income to support yourself, you're not going to be expected to live off of Canadian hot dogs. Not that there's anything wrong with Canadian hot dogs. I grew up on Canadian hot dogs. But it's sort of to shift that balance so that there's not a discrepancy in one spouse's standard of living compared to the other. So non-compensatory or that needs-based support reflects the interdependency that develops as a result of a shared life, and this idea of reliance and expectation that you're being taken care of financially from your partner. So often people assume that an income disparity between two spouses means that there's automatically entitlement, but that's not the case. That's also to say, when we go through the calculations, and we'll discuss this a bit more later on, if the formula or the calculation produces a zero range for spousal support, it doesn't necessarily mean there's a lack of entitlement, because it could just be the payor doesn't have the ability to pay, or maybe, the net disposable income is being taken up by child support. So once there's no longer child support, it's important to keep all these things in mind, because there's going to be a lot of moving pieces. And it's also, of course, why it's important to speak to a family law lawyer to determine, like, what are your rights? What are your entitlements? Or what are your obligations? You may not know that you have a spousal support obligation yourself. So ultimately, if there's no finding of entitlement, the SAGs are not applicable, but it's really important to make sure that you ensure all of your boxes are checked, and you're, entering into an agreement or going through the court system accordingly. Again, lots of information thrown right at you.
So much to unpack there. And we're getting lots of great questions coming in, and thank you. Submit your questions, and we're going to try to get to as many as we can. You want to think of, what a spouse is as well, right? Doesn't necessarily mean you're married. If you are married, you have rights that flow from pursuant to the Divorce Act. Common law spouses have rights too. There's a question in the box about a 23-year common law relationship. Fairly significant. Looks like there's need and perhaps ability to pay. Certainly get legal advice. Limitation periods, want to be mindful of that as well. The SAGs, sometimes judges will refer to these as the goalposts, right? They're going to give you ranges of support, and we'll talk about it some more, whether short-term, mid-term, long-term, whether your support should be at the low end, the high end. We're going to talk about some factors. And the other thing I just want to add in here, Joseph, with your permission, it's not driven by gender, right? The court doesn't care about the plumbing. So if the wife has a higher income and the husband can't meet his bills, then it's going to flow the other way too. So we've moved away from this idea of support's only payable to women, because that's not the case, and we have same-sex partners now as well. So what's our next topic here? What are we moving into? Joseph, what we got up next?
Yeah, so we talked about the fact that there is an obligation, and sometimes it's a difficult pill for people to swallow, but there's always a question of how long the support needs to be paid.
Right.
So Shanza, do you want to talk to us about duration?
Yes, for sure. So the SAGS is pretty detailed and it does provide a formula for determining the duration of support. And Russ just mentioned the formulas and the guide to provide a range for the duration. And there are factors that can help narrow down where in the range the recipient might fall. If you have children and you're paying child support or receiving child support, then that might also change the duration. So the basic formula says that where there is no child support obligation, then the duration of support relies on the length of the relationship. And what this means is that the amount of support and the duration of support increases the longer you have been together. The guidelines say that for every year of marriage or cohabitation, the duration of support is half to 1 year. So for every year you were with your ex-partner, that's about 6 months to 12 months of support that you could be eligible for. So an example for that could be if you are in a relationship of 12 years, the range that you would get is 6 to 12 years of spousal support. So the higher end of the range is the entire length of the relationship, and the lower range would be half the length of the relationship. The formula also identifies situations where there could be indefinite support. And indefinite does not mean forever. It just simply means that there's no initial time limit that is imposed, so the duration is unknown. There's two circumstances where this is applicable. If your marriage has been 20 years or longer in length, or there is something that's called the rule of 65. And essentially, this rule allows where marriages are shorter, 5 years or longer, but it allows for support to be indefinite because of the older age of the parties. The whole idea behind it is how age can affect the ability of a person to become self-supporting. The rule says that you basically add the years of marriage plus the age of support, the age of the support recipient at the time of separation. And if that equals to 65 or more, then the support can be indefinite. I'll give an example. I know it's a lot of math that I'm throwing, so I'll give an example here. I'm not good at math, I'm a lawyer, so an example of a rule of 65 would be if we have someone who is, let's say, 55 years old and they were in a 10-year relationship. So if you add the age and duration 10 and 55, that equals 65, which means the rule applies and the duration of the support is going to be indefinite. In practice, I know like indefiniteness is not very, it doesn't provide a lot of detail. So indefinite support for long marriages, usually I would say the time frame is up until the retirement of the pair. And the whole idea is it's indefinite because there is entitlement to support. And the SAGS does not want to put a time limit, a time frame to it because it's a long marriage, a long relationship. So it really depends on the families and how much support should be payable. Now I'll move to if you have children. So the formula for if you have children is a little bit less straightforward. Generally for longer marriages, the same formula is used, which is the length of the marriage, everything that I explained earlier. But there is also a second test, and it's called the age of children test. The test is used for shorter marriages for less than 10 years. And for this test, the range is determined by the youngest child and when they start and finish full-time school. So at the lower end of the range is the number of years until the youngest child starts full-time school. And at the upper end is the number of years until the youngest child finishes high school. The whole idea is to apply the two tests, and then the range for duration is usually determined by whichever test produces the longer duration. Now, I know these are very wide ranges, 6 years, 12 years, right? So there are factors that can help narrow where in the range the spousal support amount should be. You will want to look at things like, the court will look at things like, I know, Joseph, you kind of went into some of these factors early on, so I'll just give a very quick overview. So we'll look at things like, is it as Steph mentioned, is it a compensatory claim? Look at the recipient needs. Is there limited income, earning capacity? Is age a factor? Kids, number of kids, their age, their needs and standard of living. All of this will help determine which side of the range to lean on. And on the flip sides, we also look at the payer, their needs and their ability to pay, any compelling financial circumstances that can guide the needs of the families, debt, prior support obligations, disability, illness. All of these can help narrow down the range. Sorry, I know that was a lot, but
I know, I feel like
I'll
there's
take a break now.
so much to talk about, right, with spousal support. And just to sort of branch off on what Shanza was saying, like there are so many different factors that will impact, the length of how long spousal support could be payable, the amount or the quantum of how much support is payable. So all of these factors that the courts or lawyers will look at when calculating support will be, how much is how much difference in income is there? Do you have children together? Who's been caring for the children primarily? What are your ages? What are the roles that you had during the relationship? And like, what is your ability to support yourself or to become self-sufficient? Does one spouse, have an injury or something that limits their ability to work? When did that occur? So often when, we have clients or people coming to us who've used an online spousal support calculator to get an approximate idea of how much support they will get or how much support they might owe. You know, it can give a ballpark, but it's always important to keep in mind that those free online calculators will only consider, very, very basic factors. They might only consider your employment income, they might only do simple calculations, and there's so many intricacies to consider. Are you going to be using the with child support formula or the without child support formula? Should you be using the custodial parent formula, right? Have you considered any union dues? Is there passive income or a secondary income that should be included in the calculations? What income should be used? Is there, is one spouse underemployed or purposely underemployed and they should be imputed with an income? Another factor that often, sometimes comes up is when a payor spouse's income exceeds the ceiling, as they call it. So the SAGs say if the payor spouse has an annual earning of over $350,000, that could impact the formula significantly. So the last thing to really consider, and that needs to be discussed when you're drafting an agreement or you're talking about support, is that interrelationship between the property division for married spouses and spousal support. So there's so many things, there's so many moving parts. There's a wealth of case law that helps lawyers and judges and the courts navigate the SAGs because they are advisory guidelines. Unlike this child support, they're advisory guidelines. And like Russ said, it's a goalpost. And, every family, every circumstance is different, it's unique. So the quantity, the amount of support, the duration of support, how long it's going to last, that will be unique as well. And, lawyers, they're always going to ask you, we need transparent disclosure. We need to know what your income is, how much are you making, how is it broken down, and that's going to help aid in their ability to give you advice on what support obligations or entitlements there are, and also to ensure that the appropriate amount of support is flowing.
And the SAGs also have a separate booklet telling you about factors that will cause support to go up or down. Disability, children, like Steph touched on some of them. There's a whole book that you can go through too, depending on what side you're arguing, right? And find an argument that fits the claim that you're defending or making. Question came in about a limitation period. There's different limitation periods for different claims. If you're going pursuant to the Divorce Act, the Family Law Act, if you're common law, you're not sure, go see a lawyer. You don't want your limitation period to expire. Then it's going to be even more work to try to make your claim. But that was a great summary stuff.
Yeah, for sure. And I think what's really crazy, a lot of people question, even lawyers question, is that they fully don't understand that the spousal support guidelines are not law. People think it's law, it is, but it's not. But they're just simply guidelines. However, judges more often than not base all their decisions on spousal support on those guidelines. So
Yeah.
really they're long.
There's so many ranges, right?
Yeah.
Like these goalposts can be miles apart. Really, some of the triggers, and we'll talk about it, is it temporary? How long am I on the hook for? Or how long can I receive the support? Or like Shanza said, is it indefinite? Now, that doesn't mean you're gonna pay support forever, but the claim is indefinite. So depending on incomes and what happens later on in life, retirement, it may be adjusted up or down, or it may end, or you just keep paying it. It's complicated.
Speaking, I was gonna say, speaking of payments, Shanza, I know there's the difference. People either can do the lump sum or the periodic payments, the monthly payments. Do you want to talk about that?
Like buying a car, right? What are the options? Which box am I gonna finance, layaway?
Okay, so right, Joe, you just said it. It's either periodic payment, regular monthly, or of a lump sum amount. It's a matter of preference and means. If you are entering into an agreement, for the difference between the two, lump sum award provides more of a finality. Periodic provides more flexibility, and it does allow for the amount to be changed for any change in circumstances if they do occur in the future. You can't do that with lump sum because it's paid out already. If you are in court, the court can order lump sum too. You don't need to prove any unusual circumstances, but courts will, like I said, it's a matter of practical means as well, just as much as preference. For a lump sum award, there has to be means to make that award. Is there capital available to fund that amount? If there's property division or equalization payment, then that can make lump sum unnecessary because you're already getting that equalization payment if you're the receiver. Also, the fact that a lump sum cannot be adjusted in the future for any unforeseen circumstances, these can all mitigate against a lump sum. This is all true, like if you are in court. If you are considering between the two, there's also tax considerations to consider. Normally, lump sum support is not tax deductible. It's also not taxable to the recipient. This is different from monthly spousal support, which is normally deductible by the payor and taxable by the recipient spouse. Courts normally do try to adjust the undue tax disadvantage or advantage by reducing the face value of the award by a certain percentage to account for the tax consequence. In terms of any benefit, if you're opting for lump sum, it does allow for support obligation to be fulfilled immediately with a single payment. Any further contact between the ex-spouses on that point can end if there's no other ongoing issues. It can also provide more finality. It eliminates the risk of variation in the future. The paying spouse gets some sort of certainty. The recipient spouse can be saved from a variation that may eliminate or maybe decrease the support in the future. The recipient spouse get access to capital at once, and they can put that money towards maybe an investment or buying a home. Also, if there is a risk that the payor spouse may not pay, a lump sum in that case can reduce that stress. You want to look at ongoing there. Oh, and if you have lump sum, then you also, there's no need for ongoing financial disclosure for that end. At the same time, the finality of a lump sum award can create disadvantages. If we have a payor spouse, especially for a payor spouse, if they in the future have a reason to terminate regular spousal support, but if they already paid a lump sum instead, they have no recourse. Courts understand this, and there are cases where they have denied lump sum and they refuse to assume that the financial position will remain unchanged. And then, as I mentioned earlier, there's indefinite support. And in those cases, it might not be appropriate or it might not be easy to determine what the lump sum spousal support amount should be. So when making these awards, courts will try to look at all of these to make a fair determination. And yeah, that's all.
So much to unpack there. That was great, Shanza. You know what I've seen quite common is blended payments. So we're going to do, this is what I like about support. you know, you can be pretty creative. So you're going to do a blended payment. So let's just say we're getting divorced, and if I pay the full guideline or SAG amount of support, I'm not going to qualify for a mortgage. But if I pay a lump sum towards my support and drop my support payments, that may make me qualify for a mortgage, and I can get financing. On the other side of that, the recipient spouse may not have the deposit to buy a house. They have the income, but no down payment. So they may want that lump sum to buy their own house and then use the reduced support payment to get the financing. So, you know, lots of creative solutions here. The question came in about transferring property in lieu of support. This is the same idea. So if you do your equalization, you can move a cottage or a home over, value it, calculate what the lump sum portion of that asset would be, and then figure out if there's any support left over. Strategically, this is really important. Let's just say hypothetically, you want to get remarried. You might be entitled to indefinite support, but remarriage, we're going to talk about in a moment, might trigger a reduction or termination of your support. So why not lump sum it out now, right? Take the money, go get married. You've got your support claim. Also strategically on the flip side, if my client's paying a lump sum, I'm going to want to make sure I get a spousal support release. So if the spouse goes out and blows it on gambling or drug addiction or the new partner, whatever they spend the money on, we don't want him or her coming back in 2-3 years to take another kick at the can and shake the money tree, right? And say, I need support. I spent it all. So if you can negotiate that release, it's going to provide you with some certainty. You want to make sure the other spouse has proper legal advice and disclosure to make sure it's enforceable. But if you're paying the support lump sum, get your release. So if things go badly at the other end, you're going to be protected. And I had a case actually, this is kind of interesting. My client had a spending problem, and the other spouse knew when they got the support lump sum, it was going to be gone, right? Couldn't control the spending. So we spaced it out. It was lump sum, but she was only entitled to receive a certain amount each year above what a support payment would be. And if she needed to draw on the capital of the lump sum, an explanation would have to be provided. And we agreed to a third-party arbitrator, you know, a home repair or something of this nature. But if it was simply just to go spend the money, then that wouldn't be sufficient. So you can be really creative in terms of support. That particular scenario was a bit paternalistic, but the pair didn't want to make sure the money was still there for the spouse several years down the road. So really creative in terms of your options on lump sum.
For sure. And Shan's also brought up the fact she did talk or tie in the tax implications associated with the spousal support payments. As Shanza said, you know, lump sum payments don't qualify for a tax deduction, whereas the monthly spousal support payments are tax deductible, sorry, for the payor, and they count as taxable income for the recipient. So that's also too in terms of, you know, looking at your financially speaking, how your taxes will pay out for the following years, what's better for you in that way. So there's so many different things to consider. And I know we've talked about, you know, the calculating of support. We've talked about when people are eligible, but oftentimes we have clients coming to our office, you know, either wanting to vary the support that they're paying or terminating it altogether.
Okay, Joe, are you on me to talk about variation and termination?
Yes, please.
Okay. So to change a spousal support order or to end spousal support, you do have to prove a change in circumstances. It could be a change in support payer's ability to pay or the recipient's need for support. The guidelines are very helpful. They do provide some comments on very detailed comments on various material changes that may allow for a variation and termination of support orders. So for example, the guidelines describe things like income change, that's one of the more obvious ones. The formulas can adjust to any changes in income. If the payer's income is reduced after separation or after an order or agreement, the range for the new amount can be calculated and adjusted. There may be issues around material change like voluntary underemployment. The courts will ensure that the change wasn't voluntary or intentional to misguide. If the parent's income is reduced significantly, then their ability to pay child support may also become an issue if there's children and child support is being paid, and that may reduce the spousal to zero because the priority is given to child support. The guidelines also recognize things like job loss, disability, illness affecting the payor or even the recipient. If there's remarriage or there's retirement, all of these are changes that can result in a variation. In terms of procedure, any spousal support order that are part of a court order or an agreement that has been turned into an order, they can all be changed by way of a motion to change. Your order can also be changed on consent of both parties. If both agree to the change, and then most likely you don't really need a court appearance because it's on consent. But if it is contested, then the party seeking the change will have to prove that there has been a material change. This is a legal test that you have to meet. For something to be considered a material change in a court order, it has to be something that would have made a difference in the original order. If it was something that had been known back then. Also, it can't be something that the parties or the judge had already considered in the original order. So this can be a difficult test to meet. If whatever change was, maybe it was something the court already considered, or it was anticipated or accounted for in the original order. And in that case, you may think it's a material change, but it won't be a material change. I know we're only doing an overview, so for every change, there's so many considerations. It's hard to go into details here. I can't go into details, but we're just giving an overview. But for example, for retirement, there are safeguards. If someone retires early, meaning before they turn 65, and it's not because of health problems or any other special reasons, the court might see it as a choice. And if the court thinks the retirement wasn't necessary or reasonable, then they might not change the support payments. A lot goes into variations. There are avenues to change an award if there has been a material change, but that's the question. Is it a material change or not?
Come on, Shanza. Listen, when you entered into that order, you knew you were going to retire. That's not a material change. You should have negotiated a provision. That kind of takes me to this point, right? Take a look at your agreement in your court order. It may actually tell you when support ends. Upon retirement, maybe the shelf life of support is only 7 years or whatever you had agreed the length would be. Steph mentioned kids coming off child support could be a change where there's more income to share. The agreement, we talked about this last week, may have dispute resolution clauses that you need to follow before you commence a court proceeding. A couple other loose ends we don't have on our agenda tonight that are just coming to me now. You want to be mindful of life insurance too, right? If you're receiving support, you want to negotiate that there's the appropriate life insurance in place to cover the lifespan of that support order. And we have calculators that can tell you how much life insurance you should have in place, and should be proof that it's renewed every year and that you're the irrevocable beneficiary of that policy. The other thing we didn't talk about or haven't talked about yet is the Family Responsibility Office. We talked about this last week. If you've got a court order and agreement that's being enforced by FRO through garnishment or other means, and there's a termination provision or there's not, FRO won't change it unless there's an agreement of the parties or a new court order. So you may want to think about that, how to deal with FRO at the back end when the lifespan of the supported order ends. So I hate to say it, it depends, right, Steph? There's so much going on here, so many loose ends when it comes to support.
Always depends.
Get good legal advice.
And Russ, I know you spoke about it earlier in the show, podcast, webinar, Zoom series that we talking about cohabitation and remarriage. Can you maybe speak to that a little bit more and how that could sometimes qualify as material change?
Mhm, mhm. You know, that's a great point. You may say, okay, I've got indefinite support, but that doesn't mean it continues indefinitely at the level you negotiated. So sure, your claim still exists, but let's just say you remarry. Now your partner has a good income, so your need for support drops. And that's an argument to say your budget's dropped, you don't need this level of support, we're going to reduce your support. Many separation agreements I see, and sometimes even court orders, will say remarriage will terminate support. So I've got clients who live with somebody and won't get married because it's going to terminate their support. Sometimes they do get married, and you know, the motion to change comes, and now you're in litigation for 2 years because you weren't clear at the front end what happens with remarriage or repartnering or cohabitating. What is cohabitating, right? 3 months or more, 2 years, kids, no kids. You know, you want to be specific. Any
Good
kind of gray area is going to open the door for the judge. It's going to let the lawyers come in and say, well, it depends. Let's go litigate for a couple of years. That's what you want to avoid. The cases that are successful in reducing or terminating support with cohabitation and remarriage that I see, the judges will usually do a step down in support. So what we'll see is, just hypothetically, let's say your first order is $1,000 a month coming into you if you're the recipient. The judge is going to say, well, okay, well, you know what? You've remarried. We're going to glean you off the support order. We're going to reduce it maybe by $200 a year for the next 5 years. So we'll go $800 for a year, $600, so on, then it ends. So it's not, courts try to avoid it being like a tap where you just shut it off immediately because you've got bills, you've got your budget, you've counted on this support order as part of your planning or your financing. But we'll often see a step down approach to support if there's a remarriage or a retriggering, because that obligation that was created during your first relationship is now shifting to your new partner. Now, sometimes people remarry people without a good income and they still need support. So that's another factor to take a look at. But just another, you know, what I would suggest for our audience, and think about this, right? What's going to happen if I enter into a new relationship? Do I care if I get support? Yes, I care. Okay, well, put that into your court order agreement saying repartnering or a new marriage is not going to terminate this support obligation. And that makes sense. If it's a 25-year marriage, you've helped create this wealth, there's a strong compensatory support, you help your partner develop a career or a business, you should continue to benefit from that. It doesn't make sense if we're looking at maybe a 3 to 10 year marriage with no children and you're back on your feet and the need to support ends. So lots of wiggle room, lots of things to consider, but we're just giving you a flavor today in terms of, you know, what to look out for.
No, exactly. There's so many elements that go into it. And at the end of the day, you have to truly see if A, you know, you're eligible, and B, what are the necessary steps that I need to take, you know, in order to sort of compound that eligibility. And, you know, we always talk about finding the right lawyer and, you know, preparing your case. Russ, what should people do if they find themselves in this situation?
Finding the right lawyer, and preparing your case. Well, there's lots of ways to find a lawyer. You know, librarians, friends, family recommendations. Google has reviews. Law Society of Ontario, if you reside in Ontario, has a lawyer referral service. Do internet searches. Try to get a recommendation. I would suggest try to meet with a few lawyers if possible. Lawyers can be quirky, right? Some people tell me they call lawyers and they never call them back. or they get an appointment 3-4 weeks out. So we're really mindful of that. We try to get people in with a day or two because we know things can't wait. And get a feeling. What's important here is you want to be able to communicate with your lawyer, and be able to have a good relationship with him or her, and be able to tell them your story and tell them what your goals and interests are. A good lawyer is going to be objective, is going to provide you with balanced recommendations. A good lawyer is going to give you bad news if there is bad news. Last thing you want, judges tell me this all the time, the client should not be hearing bad news for the first time from the judge, right? That's a failure. If the judge is telling you something bad, your lawyer should have anticipated that and given you the advice before walking into the courtroom. If he or she doesn't, then you're not getting effective representation. And I'll give you an example of what I'm talking about. Sometimes I get clients coming in after a 25-year marriage, decent income, their spouse doesn't have a good income. You say, I'm not paying support. I don't care. He or she cheated on me, or whatever the reason is, I'm not paying. If it's a lengthy marriage and there's a clear obligation to support, I'm going to tell that client, you may not like this, but you have a legal obligation to pay support. You can try and negotiate a different outcome. You can try to lump sum it out like we've been talking about tonight. But if I don't tell the client at the front end, this is a risk, you can instruct me to argue a case and not pay support. You're probably going to lose, but you're not going to hear it for the first time from the judge. You're going to hear it from me. So you want a lawyer that's going to give you balanced advice, give you the bad news and the good news. You want a lawyer who's going to be sort of a chess player, right? There's a lot of strategy that goes on. There's a lot of rules, lots of forms, lots of deadlines, lots of things to consider, including the personality of not only your spouse, but the lawyer your spouse chooses to represent him or her. We find, or at least I can speak for myself, the most satisfied clients are the ones who can control the outcome in some fashion. That means collaborative practice, negotiating a settlement outside of a courtroom, where you can come up with something that's acceptable to you and your spouse, hopefully in your children's best interests. Usually is going to be the best result. You'll find lawyers and you'll find spouses who want to burn everything to the ground, right? They're upset, they don't care, they're not thinking clearly. You want to try to avoid those outcomes, because if you go to court, you may not even get a chance to talk to the judge. You will at your trial. The judge is going to know very little about you and will be asked to make a decision that's going to affect your property, your income, your children. And it may not be a decision you agree with. So if you can control the outcome, negotiate a fair resolution with your lawyer. That's what I'm probably not even talking about what I was asking. Yeah, I guess I'm kind of on topic. So find something that resonates with you, that you can communicate, that's going to give you bad news and good news, that's going to look towards resolution. Some cases shouldn't be negotiated, right? If there's abuse or somebody can't parent, you need to safeguard your children. You need to get a safety plan in place. You need to get out of that environment. You know, some marriages just shouldn't continue. But it's all fact driven. So I don't know. So I'm kind of wandering here, Joseph. But
No, it's good. I think, no, I think, at the end of the day, as with every advanced family law topic that we've discussed, it's tough to navigate it on your own. And that's what we're here for. We're here to support the public in navigating, these difficult matters that they realistically can't do it on their own if they want to fully exacerbate and exhaust their legal rights. So I think it's really important that, they use these resources and just know that we are here to help, and that we are always able to provide, the clients and the public, let them know, it's all about providing the knowledge and letting them know what their rights and what they're entitled to, as well as their obligations sometimes when people come and they don't want to hear the bad news, but we tell them the obligations as well. And I think it's really important, or just as important.
Yeah, actually, just sort of to go off of that, I had an interesting conversation the other day and just comparing, you know, just like you have a relationship with your spouse, you're going to have a relationship with your lawyer. You're going to be talking to them, you know, frequently, sharing the details of your relationship, your separation, about your kids, about your goals, but also about your fears. So, not everyone is always going to mesh, and that's why, finding a lawyer that you feel comfortable being transparent to, that you feel comfortable sharing with, and that you trust is going to be extremely important. And the benefit that I've seen, at least at within our firm, is we have so many lawyers that have so many strengths, and we can lean on each other. We're not like one of those, we're not suits where we're stepping on each other to try to get to the top. We truly do work as a team. So, if I need some advice, or I need to brainstorm a legal strategy, I need someone to play devil's advocate for me, I can give Russ a call, I can give any of the lawyers, I can give Shanza, Joseph, I can call anybody and really talk through, if you were the other side, what would you do? Okay, well, this is what I would do. So it's really beneficial to have that balance, and we have so many great minds and great personalities. So I often find that it's super beneficial with our firm, because you'll find the right fit.
For sure, for sure.
You're getting a team, right? We've had cases that are multi-million-dollar cases with boxes of disclosure, and it's impossible for one lawyer to go through that effectively. We team up 2, 3 lawyers, some senior clerks, bring in some technology, and work cooperatively, and that's the key. And in terms of expectations, it's okay for a lawyer to manage your expectations. They're looking at it after your best interests. Oftentimes, and I still get this, clients will say, what's my percentage of this? What's the percent I'm going to win? We can't do that like that. There's not, I can say there's 74% that you're going to get 80% of your support order, right? Like, that's mumble jumble that doesn't mean anything for a number of reasons. We don't control the facts, the judge does. So if they determine the outcome, we can give you advice in terms of what they've ruled before, what they're likely going to do on this particular case. But you're letting a third party decide this outcome. So lawyers can't say this is exactly what your outcome's going to be with 100% certainty. Very rarely can you. And so you want the balanced advice of the strengths and weaknesses of whatever claims you're putting forward or arguments that you're making. So I agree with you 100%. Steph, that is a great insight.
For sure. We do have time. We do have a couple questions from the audience. This is a really good one. I think it can also be a little bit of a roundtable discussion as well. The question is, can spousal support be waived and under what circumstances? So does anyone want to take a stab at it first, and then maybe we can have a roundtable after?
This just reminds me of the question we got when we were doing child support. And I got that question. I was like, can I not pay child support? And I was like, no, you have to. Well, here, same is not true for spousal. You can waive it. You can enter into an agreement, and you can decide. You can be so much creative with spousal. You can decide on any amount you like. You can agree to the duration as well. There is a lot of flexibility. But it is still a good idea. Like, I know there's a lot of flexibility, but it's still a good idea to come to an arrangement that is fair, because there is a potential that a court could later choose to disregard the agreement. So try to be fair, I would say that. And I say you do want to get independent legal advice if you are entering into an agreement, and get that certificate, even to make sure that the agreement stands up in court if your ex-spouse do end up dragging you to court, even though you did negotiate that agreement in good faith. So get that advice. I'll let someone else speak. Short answer, yes, you can waive spousal.
Yeah, and I think it's really, really important to, in that waiver, be as detailed as possible. We often see very, very lengthy waivers that say you understand that you may lose your job in the future. You may get into an accident and may no longer be able to work. You might, there are so many if, ands, or buts. I wish we had a magic crystal ball and could tell the future. I would win the lottery tomorrow, but we don't. So it's really important to make sure that with that waiver, it's very detailed, so that 5-10 years down the line, your husband, your wife is not coming back and saying, look, I'm on disability now, I can't afford to live, I need to pursue spousal support from you. You want to make sure you protect yourself from that. So
Well, we see those, a lot of the spouse, like, well, not even spouse support, but the separation agreements in and of itself that contain the spouse support clauses getting overturned. And it all comes down to intention. What was the intention of the parties when they were drafting the agreement? So as Steph said, if you're not as detailed as possible, intention becomes cloudy, it becomes up in the air for interpretation. And judges, they like going through that with a fine tooth comb and really just nitpicking at it.
People are entitled to make a bad deal, right? It's not our job to make everything perfect. Our job is to give them proper legal advice, make sure they have full disclosure, to make sure they know that if it's a bad deal, to tell them what the bad deal is. Say, this is your compromise. This is what you're leaving on the table. But sometimes what I'll do, if I'm representing the pair and there's going to be a release, I'm really concerned about the recipient's state of mind. So because I don't want them to come back 5 years later saying, I wasn't thinking clearly, I had a lawyer, but they didn't explain it to me. So in situations like that, especially in a collaborative setting, I'll bring a family professional involved to make notes and provide assistance to the person who's choosing to make a bad deal. It just as an extra safeguard. So if there's an attempt to set aside the agreement 5 years later, I can say, well, we did everything we could. We brought a social worker in. They had independent legal advice, full disclosure. And if all those boxes are checked off, I think a judge will probably require the person to live by the agreement they signed.
And it shows capacity as well, right? It shows that they had the capacity to make that decision. And
Yeah.
on that, do we have time for one more question? Yeah.
2 minutes, fire away.
So we have one question. It was sort of already discussed and answered by Russ, but we can maybe go into a little bit more detail. The question says, what happens if my ex-spouse refuses to pay the court-ordered spousal support? And I know that Russ talked about FRO, and that's definitely one of the options, but the court can step in to enforce spousal support payments if needed. And this enforcement can really happen if there's either a court order or a separation agreement that's legally binding and enforceable. And as Russ said, the Family Responsibility Office, or FRO for short, can also help out with the enforcement. And they step in if there's a court order in place or if the separation agreement has been filed with the court and is registered with the FRO for enforcement. We've talked about it before, we've defined it, but we'll define it again. FRO is a government agency that handles collecting support directly from the person, so the payor who owes it, and it keeps track of the amounts paid and then forwards that money to the recipient. But FRO can only assist in collecting support if the person who owes it lives in Canada, a US state, so any one of the 50 states, or about, I believe it's 30 other countries that Ontario has these agreements with, and these are called reciprocating jurisdictions. And the problem that lies with this is that if the support payor lives in a country where Ontario doesn't have this agreement with, then FRO's hands are tied and they can't really assist with that. And then in that case, you'd have to navigate the legal system of that country to help you get your support payments. So it is difficult, but the 30 countries that Ontario does have a reciprocity agreement with are 30 countries that are all usually within like the Hague Agreement cases or Hague Agreement countries. So they're usually the primary countries that Ontario does dealings with. But then again, there are also a lot of countries that are not on that list. So it's also important to take note of.
Yeah, real quick. If you're worried about somebody leaving the country where our government agencies can't track them down, being FRO, you can get security for support in terms of assets here in Ontario. Like Joseph said, lots of tools in the toolbox. You flip it over to the Family Responsibility Office through a court order in a support deduction information form. You're looking at garnishment of wages, suspension of driver's license, take away your passport, affect people's credit rating, even incarcerate them. So there's lots of tools that could be used to enforce a support order. And you're going to want to make it retroactive to the date they stop paying. But great question, Joseph. Steph, what do we miss there? Do we get everything?
Yeah, it's a lot. There's always so many things to consider. There's, like you said, so many tools in the toolbox, and that's why getting advice, speaking to a lawyer is gonna really utilize your options. So over to you, Joe.
Yeah, I was gonna say on that note, it's 6:01. It's officially after hours, or the commencement of after hours, I should say. Thank you everyone for joining us today. Thank you all for sticking around until the end.
Great stuff. Excellent work tonight, Joseph. Shanza, Steph, thank you so much. And thank our audience for joining us. It was a great evening.
Yes,
Thank you,
thank you
everyone.
everyone.